everyone. I'm Stephanie Gerald, and I put both my titles here because for two reasons. I am a law student, so I don't know copyright law like a lawyer. I haven't had a course. But I'm also a content producer. I work for a tech company, and I create original content for commercial use. And so a lot of times I am dealing with copyright law in my job.
What does that mean, content producer?
I will tell you. So what I do is, if there's a part of LinkedIn called LinkedIn Learning, and what we do is we create courses, and I am a producer of those courses. So I work with experts all around the world, and we create, and I specialize in the advanced technology courses on LinkedIn Learning. So I work with the experts in the field. So I work with a lot of data engineers, I work with a lot of software engineers, to create content, learning content online, so I create these courses with them. Does that answer your question? Great. So I say that because I am not an expert, but I kind of have, this kind of affects me, right? I'm in both of these realms a little bit. So what I'm gonna do first is lay some foundation, and we're gonna get a little technical at the beginning here. All right, so does anyone know anything about how large language models are trained?
No.
Anything at all?
You're just given info.
Good job, yes.
That's
You
all I
just
know.
give them massive amounts of info. If you think about it, we are training a model, a computer, to speak with humans the way humans know how to speak, right? And so to do that, they speak ones and zeros. We speak English here. So we need to give it enough English language to process with us. So here's the more technical part. This I learned from one of my experts who is an AI engineer. And she taught me how training a large language model works. And it happens on different layers. And this is very generalized. I won't be super technical here. But there's these 3 layers. And so first, they happen in stages, is a self-supervised learning. And so at this point, this kind of learning helps the model to understand language and specific domains, all right? So they need to know how to speak, basically, with us. And then the second layer comes in after the first layer. So once they know the language, then there's supervised learning. So the model, this learning enables the model to follow instructions and generalize to new tasks. So our keynote speaker spoke a tiny bit about this, where an engineer is actually going in and giving instructions. DNX spoke about it a little right here as well. That is like supervised. The engineer is going in and supervising, giving instructions, generalizing those new tasks. And then there's a third layer that happens after this layer, and it's called reinforcement. And this is basically the layer which trains the model on, basically, on a low level, good and bad behaviors. What do we want it to do? What is harmful? What is described as harmful? Which is why when you talk to ChatGPT, it's very apologetic when you do when it does something. Oh, I'm so sorry. This is probably where it learned that, right? So this is basically how it's trained, and these layers happen one after another. All right, so which level do you guys think needs all of that massive amounts of data? Which level is all that data?
All of them.
What's that?
All of the levels.
All?
Number 3.
Number 3?
Number 1.
1?
1.
1? Okay, we have 3s, we have 1s. It's actually 1, so those of you, because this is where we are learning the language. So it's where all of that data is thrown in and it's like processing the data, it's like learning how language works. What word comes after a next word, you know, that kind of thing. All right, so now what I want you to do is forget your lawyers, you're in the legal field. Let's be data scientists, okay? Let's pretend we're the engineers. We are building a large language model, right? We're here at this first layer, self-supervised. Where are we going to get our data? We want our large language model to speak with humans in a very human way. We want to train our large language model to be able to understand the nuances of language. Where can we pull that data? Where can we get like how people speak to each other in informal language, in formal language? What do you think? Where should we go?
Mr. Rogers.
All over the internet.
Mr. Rogers. The internet. Yes, let's scrape the internet. That's a great way. And I put this quote up here, and it's actually a quote because I hear this so much in my job at LinkedIn Learning. So I work with these data scientists, and I don't know if you know this, there is a culture of sharing code that is very different in any other profession that I've seen. So when you are working with engineers and you're coding and you share your code and you're working on these projects together. And it's almost like a culture of just like, oh yeah, I did it this way, it's faster this way. People on the internet go through and just share each other's core code, they call it forking, and they use it and that kind of thing. So there's this whole idea.
Unless you're Apple.
Unless you're Apple, that's right.
So it likes gossip.
That scraping the internet is almost just a thing that everyone does and it's okay. Copyright is never thought of. So I work for LinkedIn Learning. This is a commercial product that we're putting out. I work with these experts who all their job is coding, you know, that kind of thing. Often, I have to teach them about copyright. I have to say, no, we can't use that. And they are so surprised all the time. So, this is really good. All right, so, we are engineers, we've scraped the internet, we've trained our model, we've gone through our layers. We're awesome, right? What can happen? What troubles can we come up with? Well, what we're gonna do now is go through what troubles came up with OpenAI with their large language model. So, this was very recent, December of 2023. So what, four months ago? New York Times sued OpenAI and Microsoft, and I put Microsoft in parentheses because we're not really going to talk about the Microsoft side. For those of you who know, Microsoft owns LinkedIn, so I'm actually a Microsoft employee, so we'll just put that aside. They have other issues. We're going to talk about OpenAI because they're the ones who made the large language model. So, New York Times sued OpenAI for copyright infringement. So, as a good law student, let's look up what is copyright infringement. Let's look at those elements. To prove copyright infringement, a copyright owner must show that the alleged infringer has access to the copyrighted work. What do you think about that access? And that the allegedly infringing work is substantially similar with the copyrighted work, right? So, with access, what I know in my job, scraping the internet is way easier than you even think it is. So we're talking about New York Times articles, right? They're behind a paywall. So they shouldn't be using that, right? They should be paying for those articles. But scraping the internet, you get an account, you can scrape the internet, right? So, things to think about. And then
What does it mean scraping the internet exactly?
Scraping the internet is collecting the data from the internet. So when you go through web pages, you see what you see, right? There's always a backend. There's always a database behind a lot of
Like you ask
sites,
a
right?
question and the
So
internet-
scraping is pulling that data down and having I think a simplified way to say it is pulling that data down and you have a spreadsheet of all the data that's out there that you want to collect.
So on the internet, you ask a question, how do you heal a headache or something like that, and they give you an answer. That's what you mean by scraping the internet?
Potentially. I mean, it's more involved in that. It's more collecting the data that is used on the internet.
Would it be fair to say it's like, I don't know, Google articles on headaches? And it produces articles that are highly medical and original, and then people have used that derivative articles. And scraping the internet takes all, both the
Correct.
derivative and the original.
Yes.
And it copies and pastes, and then it puts it on its stuff.
Yeah.
Copy and paste,
It's
copy
like a
and
copy
paste.
paste. You're copying and pasting, you're pulling that data, you have that data to process it and do other things with.
Thank
Okay.
you.
I would say just from the technical perspective, you're not getting hit file save as when you're in a browser. Imagine every page on the internet somebody went through and hit file save as.
Thank
That's what they do when they scrape the internet.
How do they get past that New York Times paywall?
That you're getting into a realm I don't know.
Well, if someone
But I know it's easy
who's
to do.
paid and they've done it, and then they copy and paste and put it into their article, which is about that, oh, you got it, then you got it.
Well,
That's all.
sometimes it's
I mean,
easier than that.
Exactly.
They have certain things that stop a browser and a person from looking at it, but computers don't use when they scrape the internet, they actually just use numbers in the URL, they don't use names. And when they use those numbers, all of the protections tend to fall away and it's really easy to grab all the content.
Wow, that's scary.
Yes.
There's ways to get around that stuff.
It's a
Even
back
though
end
it's
thing
like-
that people do, yeah. All right, so let's go back to, we have our copyright infringement. So access. From what I know, I am pretty darn sure they have access. We all have access to it. We can log in, but they definitely have access. So that's definitely something that I know that would be there. All right, but the substantially similar, it's another thing. Let's think about that. Okay, going back to the lawsuit, we know that. All right, so they alleged copyright infringement. And then this I took right from the complaint. So the New York Times contends that millions of articles published by the Times were used to train automated chatbots, so train their large language model, that now compete with the news outlet as a source of reliable information. I thought this was interesting because I don't know about you, how many of you use ChatGPT to know what the news is? I haven't done that yet, but maybe some people do. I thought that was really interesting. The complaint also called for the companies to destroy any chatbot models and training data that use copyrighted material from the Times. So what would that mean? That would mean if this lawsuit went through, we would have a very different ChatGPT at this time. And where does that go? Because what's interesting to me about this is I also created a course recently on LinkedIn Learning where we created our own chatbots. So I don't know if you know this, you can go in as a developer or any of you, create an account, and you can create your own customized chatbot in ChatGPT. What about them? What about the one I created in my course for LinkedIn? Like, would I be, because I'm using the potentially the language model trained from the New York Times articles, I don't know. All right, so the last thing I just wanted to point out is the Times, this lawsuit is really important because it's the first major American media company to sue OpenAI. And so that's why I was really interested when I saw this. I think a lot of lawsuits are gonna happen. It's gonna be kind of crazy, so I'm really interested. And there's even a lot of more lawsuits I'll bring up. Okay, so going back to that second bullet I had there, a couple things in their complaint. They talked about the articles were used to train. So what does that mean? So that leads to potential fair use, right? Because did they have permission? Do they need permission? That's fair use. And then the other thing is what's happening now. So if I go into ChatGPT and I say, blah, 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 give me something, and I get something that potentially is a New Times article maybe? Is that substantially similar? That's that other element to the Times articles. Let's dig in. So I looked up fair use as well because I'm a good, dutiful law student. Something that I was surprised, I've learned affirmative defenses from Professor Feuderan here. And I was like, oh, it makes sense. This is an affirmative defense. So fair use, it gives users the right to use copyrighted material without permission under certain circumstances. So those circumstances are what is going to be key here. If the use is fair, the user need not notify or seek permission. So we don't need permission here, right? So this is
What's
going
the
to be
fair
the key.
use?
That's what she's saying.
What is the fair, how do you find out what's the fair use?
That's a good question. Let's find out. All right, so let's look at the other side. So what did OpenAI respond? So in February, so not too long ago, they filed a motion to dismiss a lot of the claims. Let me find my thing here. Okay. And in that motion to dismiss, OpenAI argues that ChatGPT is not in any way a substitute for a subscription to the New York Times. And one cannot use ChatGPT to serve up Times articles at will. So they're saying it's not substantially similar, right? The other thing is in this motion to dismiss, OpenAI did not dispute that it copied millions of the Times articles. So that's going towards it's saying, fair use, right? And then a spokesperson, I thought this was interesting because a spokesperson is like saying that we respect the rights of content creators, and I'm like, how? I don't know. And owners, and are committed to working with them to ensure the benefit from AI technology and new revenue models. And we're hopeful that we will find a mutually beneficial way to work together, as we're doing with many other publishers. And I thought that was interesting because that is what they're doing. They are working with these smaller companies because the smaller companies can't compete with Microsoft and OpenAI. They have to find ways to work with OpenAI. They probably can't afford litigation. I don't know. It's interesting. All right, let's talk a little bit more. So, in the complaint, the Times included examples of how OpenAI technology was reproducing those New York Times articles, which is interesting because if they can prove that, then that's that substantially similar element that they've met, right? However, in the motion to dismiss, OpenAI lawyers accused the Times of paying someone to hack their chatbot. They said it took them tens of thousands of attempts to generate the highly anomalous results. So they were not even able to do that. I didn't put it in this slide, but the motion also stated that the Times exploited a vulnerability in ChatGPT and they're fixing it, so we're good.
So it taught him something.
So this also made me think of looking back at those layers of training, right? We throw all the articles in at the layer 1, right? And then there's multiple other layers. There's multiple other things that are happening with the engineers multiple other things with the engineers that happen on those layers. So why would the chatbot spew out exactly the New York Times articles? I don't know. Things are a little interesting here. Okay. All right. So then a couple more. The filing also argued that it was legal to use copyrighted material in its systems, citing legal precedents that allow for the use of copyrighted content in the creation of new and different innovative products. And so that is the part that you were asking a little bit ago about the fair use. This is where the courts are gonna have to decide whether fair use falls in here, which we'll see, because they haven't ruled yet.
I think fair use means something which is used by public on a regular basis,
Yes,
right?
No.
I can tell you.
It's on one of my slides. You can get the slides after. All right. And then we have other lawsuits that are open right now. These are all currently open. Nothing has been said. All under the same stuff. So like the first one was about copyrighted books that were used in the training. The second one is about visual artists using copyrighted images. And then Getty Images was like a site that was has like 12 million of their images were used for the training, that kind of thing. So these are all in current litigation right now. All right, last slide. But what should we do? This is going to be a recap of some of what everyone else is saying so far. Be informed. So the reason I showed you the tech a little bit in the beginning was hopefully to show you how interesting it is to, if you know a little bit, even a little bit of the tech, and you know the law, you're able to apply that together and be more informed. The other thing I said news here, the other thing I didn't talk about, which affects reporters, like this New York Times, that's a whole other topic, but they're the ones who created this content. Do they own it? Does the New York Times? Anyway. Also be cautious and curious. Speak up. Us as lawyers, we are going to speak up, but this is really relevant, I feel like. And all of us create content nowadays, and so, yeah. What else? Does anyone else have any ideas what we can do now?